The Queen's Cartoonists, Tuesday, February 8th at 7:30 p.m. The Farmington Civic Center, 200 West Arrington in downtown Farmington. Find out more online at fmtn.org/shows or 505-599-1148.
Hey everyone, it's your host for the World Beat Show, Scott Duran, and I want you to join me every Saturday at 11 a.m., where I take you on a journey around the world and show you traditional and modern style world beat music. Music from Africa, Spain, France, Japan, China, heck, even songs and artists from the United States itself. So join me every Saturday at 11 a.m. only on the KSJE 90.9 FM.
KSJE is supported by the Farmington Civic Center, bringing a full slate of entertainment to Farmington and San Juan County. Dancing with the Farmington Stars, Saturday, February 19th at 7 p.m. The Farmington Civic Center, 200 West Arrington in downtown Farmington. Find out more online at fmtn.org/shows or 505-599-1148.
Good morning, everyone. I'm Megan Cullop, along here with Scott Michlin.
Good morning, Megan Cullop. Happy Friday.
Yeah.
Here we are.
Always exciting.
Right?
To be here with you.
Oh, good save.
Yes.
Good to see you too.
Yeah.
This week, it's another Solutions from the Street week here at KSJE.
Right.
And then, of course, next week, we'll be back with our COVID-19 Community Information Program. But for this week, we have, I think, a really important solution to a really important problem that we are seeing issues with throughout San Juan County, I think, and throughout the country. And it's not helped by COVID-19. It's still a big problem.
Right. Well, it's one of the most basic of needs, shelter. Where do we lay our head?
Very true.
Yeah.
Very true. And so we were doing some research before the show, and we found that about 30%, at least as of the most recent census figures from 2019, 30% of San Juan County folks rent their homes.
Sure. I'm a renter.
See?
Yeah.
There you go. And you're a pretty good tenant, I would think.
I'm a really good tenant.
Are you?
Yeah.
Are you?
I
Really?
It's always on time.
Let's get real. Really?
Yeah.
Okay.
Yeah.
True. And I was a landlord for a while, probably about 10, 15 years ago. And I had really good tenants as well. So I appreciate good tenants, and hopefully they appreciate good landlords. And
Yes, we appreciate good landlords.
the other point that I think most tenants are good, most landlords are good, but every once in a while, things get a little messed up.
Yes.
And that's why we have our solution today.
Yes.
Let's introduce our guest.
Great.
All
Jake.
right. Jake Parker is here from DNA People's Legal Services. Good morning. Thanks for coming in.
Hi, yes, thank you for having me. I'm really excited to talk about this.
We
it's
appreciate
a very important topic.
Yeah, you have been with the organization for 2 years now, right? You were telling me?
Yep, with DNA People's Legal Services for 2 years. I'm a staff attorney. Mm-hmm.
And you deal a lot with landlord-tenant issues, right?
Quite a bit. Right now, yeah, I'm working a lot on landlord-tenant issues. It's very important in this time of COVID and stuff. But DNA also handles other areas of law, but we only do civil, of course. So we do family law, also consumer protection like car loans, medical debt, other types of debt, government benefits, various types of that, and also landlord-tenant law.
Okay. Very good. Well, let's get into it and talk a little bit about some of the issues that you see. And so, for folks maybe who are joining us, what are some of the red flags that a renter should be watching for?
Well, there's quite a few. I mean, basically, let's start from the beginning. There is this statute in New Mexico, state law. It's called the UORA. It's UORRA. Uniform Owner Resident Relations Act.
Okay.
This is the primary state statute that deals with landlord-tenant law in the state of New Mexico. And basically, it outlines just a bunch of rights, remedies, obligations that both the landlord and the tenant have. Some red flags might be the landlord failing to meet their obligations. Some common issues I will see will maybe be failure to repair a lot of issues. We might have issues with things not functioning properly, like the electrical system, the plumbing system, heating systems. That can be very important, especially now that it's colder. But yeah, there's quite a few issues to look out for.
Okay. And let me do a follow-up, because that is the one area, and you said that if a landlord doesn't repair some things, but what if, maybe my apartment is furnished and maybe I've got a loose leg on my couch? I mean, that is, I think, less serious than maybe a non-working heater.
That's true.
Is it still the same issue, though? Should the landlord have to fix both?
That's an interesting question. I'm thinking back to the obligations of the landlord, and any amenities or services that are provided by the landlord, they are responsible for repairing. So if that couch was provided by the landlord, if the home came furnished,
right,
then I would say it's probably the landlord's responsibility. However, if it was the tenant's couch that they brought into the home,
well, sure,
then it would just be their responsibility.
Of course.
And of course, if the tenant caused the damage, then it would be the tenant's responsibility. But in most situations, most issues in the home are going to be the landlord's responsibility to repair.
Got it. Got it.
Great.
Megan, fix your couch.
I know.
Yeah.
Well, it's my couch, though, so
okay.
I could stay unfixed.
There you go.
There were some protections put in place during COVID-19. So first, what were those? Remind us all. It's been a while. And are those going to stay in place? And if they are, for how much longer do we think?
Well, it's actually a very interesting time right now for the state eviction prevention program. For a while, since the beginning of the pandemic in March 2020, the New Mexico Supreme Court entered an order that enacted this eviction moratorium. Probably a lot of people have heard about this. Basically, a tenant cannot be evicted unless they have an ability to pay the rent. And basically, it would only be applicable to non-payment of rent eviction suits. So in that type of situation, a tenant would have to prove their inability to pay. However, right now, in March, there will be a change in this program. So now we are moving into an eviction prevention program rather than a moratorium. It's a little less stringent, of course, but basically, first, if there is an eviction suit, the judge handling the case will first inform the parties that rental assistance is available. And I also keep in mind that there are multiple nonprofits in San Juan County that do sometimes offer rental assistance. So if there are any tenants out there who are having difficulties just making rent, they should contact San Juan United Way, San Juan County Partnerships, and also ECHO. They sometimes have some rental assistance available, but not always, but definitely check with them. But back to the program. So the court informs them that rental assistance is available, and then the court will ask the party, and when I say the court, I mean the judge. This is basically how lawyers talk about the court, but the judge will ask, do the parties want to participate in the eviction prevention program? And now both parties have to agree to participate in the program, otherwise the eviction hearing will proceed normally, and the tenant can be evicted normally. However, if they both agree to participate in the program, then the judge will then postpone the hearing for 60 days, 2 months. And during these 60 days, the tenant is encouraged to do whatever they can to resolve the issue that is causing this eviction suit, be it payment of rent or various issues like that.
Very good. And I guess it sounds to me then this is something maybe that most tenants wouldn't know about, this program that you're talking about.
I'd say so. I don't think the state is putting much out about this program. It's probably maybe a bit more once it starts up in March statewide. It currently is in place in Clark as well as Roosevelt County over in the eastern part of the state. But also, you also asked if there was any intention of making these things permanent. There's been no signal from the New Mexico Supreme Court or the New Mexico legislature that they want anything like this to be permanent. So one would assume that once the pandemic actually comes to a halt, that these programs would stop.
And the way it's going, that's probably never. But anyway, we're hopeful that someday it will be stopped, right? And they'll come to an end. That's true. Let me ask you a bit about leases, right? And so I think most people that go in to rent a property have some sort of lease. Is that an important thing to have if you're looking at renting someplace?
Oh, very, very important, actually. And in fact, under the UORA, landlords are required to provide written lease agreements to all of their tenants prior to the start of the lease agreement. But yeah, basically a lease agreement it's basically a contract. It's like any other contract. It outlines the rights and obligations of the parties involved here. But just like with contract law, there is law outside of the contract that has influence on the parties' rights, obligations, duties, things like that. So where that comes in is obviously the UORA. So, I mean, obviously it is very important to have a lease agreement to make sure everybody knows everybody's responsibility in terms of rent, various obligations the landlord might have or the tenant might have in terms of maintenance of the property. But yeah, I want to make it clear that tenants do still have rights as tenants, even if there is no lease agreement. And the UORA is actually written in a fairly accessible way. So I would encourage anybody to just look up the UORA, UORRA. You can find it online. It's a fairly short statute, fairly readable. You don't have to understand everything about the UORA to understand some important parts about it. So yeah, I would definitely encourage anybody to look into the law more closely.
Very good. Let me do a follow-up real quick on that about how important it is for a tenant to read the lease, because I think maybe sometimes people will they're so happy to find a place, especially these days when maybe there's a shortage of affordable, decent rental housing. They'll just sign, just to make sure they get it and don't lose it out to somebody else. But it's really important for these tenants to read a lease agreement, right? To understand the landlord's responsibilities and their responsibilities in that property, right?
Mm-hmm. Definitely. There can be various obligations that a landlord might impose on the tenant, and those will probably be in the lease agreement. So you're going to want to review that because, if you do in some way violate the lease agreement or any of your obligations under the UORA, then a person can be at risk for eviction. But given that, you can't just, hey, I've accidentally violated the lease agreement or some sort of obligation I have. You can't just be kicked out. I want to make that clear. Only courts can actually evict tenants, although landlords can terminate a lease agreement. Those are two very different things. Eviction is the actual physical removal of the tenant from the rental property, the rented home.
Sure.
And before any of that can happen, the tenant is entitled to notice that they have violated the lease and a 7-day period during which they will have the opportunity to cure or fix the issue. And then if they do fix the issue, they cannot be evicted.
Got it. Very interesting. Thank you for that, Megan.
So if I sign a lease as a renter, and then later I wish to amend it or change it, is that possible? What are the avenues for that?
Yeah, of course. It's usually better to review a lease agreement before you sign, see if there's anything you might have a problem with, and then change it or ask the landlord to maybe change a specific provision in the lease before you sign. That makes it a lot easier to change it. However, if you've already signed the lease and you want to talk to your landlord like, hey, I don't really think I should be responsible for lawn maintenance. It's taking up a lot of my time. It's increasing my water bill. I think you should be responsible for this. If you wanted to change that after the lease agreement has already started, you would need to do what is called a lease amendment, which is basically a secondary written contract that both parties negotiate and agree to and sign. And once it is signed, it basically becomes part of the lease agreement and can modify that agreement.
Good to know.
Good to know.
Very much. And there are some stories that we hear from time to time about maybe a renter where maybe the landlord hasn't fixed something in the property that they've asked for over and over again. And a renter wants to withhold part of their rent to pay for that repair. Is that allowable, or does that kind of open up another can of worms perhaps? Because then the landlord could say, you didn't pay all your rent and now you're in default of the lease agreement that we have.
That's where it becomes a little sticky. Like tenants do have the authority to withhold a portion of their rent. It's called abatement. However, they can only do this after going through certain procedures that are outlined in the UORA. And this is another reason to definitely look into the UORA to make sure you are following the law if you do want to withhold rent. So let me explain a bit about that procedure.
Sure.
If there is an issue, say, let's say a sink isn't working, it's leaking, that is plumbing, that is the landlord's responsibility. Now, if the tenant does want to make a formal request that the landlord fix that issue, what they need to do is provide what's called a 7-day written notice of non-compliance, or of termination or abatement. Basically, 7-day notice. It'll detail what the repairs are needed, what the tenant will do if the landlord fails to make those repairs within the 7 days, and basically it outlines what the tenant wants from the landlord. After those 7 days, after they provide the notice, they can choose either to one of two things. They can terminate the lease agreement, which is basically, I want out of this deal, I'm tired of dealing with this, you aren't repairing my plumbing, I'm having issues, I need to haul water. If you're having a lot of issues and it doesn't seem like your landlord is going to fix the issue and work with you, then termination might be the best way to go. However, there is also, as I mentioned, abatement, which is withholding a portion of the rent in order to provide sort of a financial incentive for the landlord to start these repairs that they are obligated to do.
Got it. But I can't withhold the rent and pay my own plumber to come in and fix the sink and use that money for my plumber, can I? Or does that add extra sticky situations to the landlord-tenant relationship?
Of course, yeah. I mean, this is actually very interesting too, because although New Mexico has fairly robust landlord-tenant laws, they have good protections for tenants. It is different by state. In some states, they do allow that sort of like, I'm withholding a portion of my rent, I'm paying this person, and now I want you as the landlord to reimburse me for repairs that are actually your responsibility. That actually is not allowed in the state of New Mexico. What is allowed actually is after providing notice, tenants can file a lawsuit against their landlord if they are failing to meet those obligations. And then they can pursue damages, which would be able to cover the cost of anything that they have suffered as a result of the failure to repair. Say in a situation, maybe the heating wasn't working and you needed to purchase a space heater that you could plug in. That could be compensable damages that you could pursue. But in addition, in this lawsuit, a tenant could ask the court for what's called an injunction. This is a legal term, it's a bit technical, but basically an injunction is a court order that comes from the court that directs a specific party to do or not do something. In this situation, if a tenant wanted an injunction against their landlord, they would ask the court to ask the landlord, or really order the landlord, to make those repairs that they've requested.
Gotcha. Thank you very much.
So let's talk about like tips for renters. What kind of tips can you give us for people who are moving in, people who are ready to move out, timing of things?
Oh yeah, that's a very important issue. Moving in, moving out, there can be a lot of potential issues when it comes to damages to the home. So when a renter moves into a home, it's very important to do a walkthrough. I think most people are aware of this. Go through everything, record everything. Often even landlords will ask tenants to write down a list of all of the damages that are in the home. However, they don't always require that. But I mean, I think tenants should take it upon themselves to gather that evidence, make sure they know all of the damage that existed in the home before they moved in, because once they leave, usually a landlord will have a security deposit from the renter, and then that portion of money will go towards any damages to the home. So when you're moving out, you want to have that evidence, timestamp photos of any damage that existed prior to the lease starting, just to make sure that you aren't going to be responsible for any damages that were already there. Now, moving out is a similar situation. You're going to want to document any and all damage that exists still in the home after going through cleaning everything and removing all of your property from the home. You're going to want to document all that damage. And this is for similar reasons. The security deposit, you want to make sure that the landlord isn't inflating how many damages are in the home, just to make sure that you are only paying what you are actually required to do. Security deposits are also kind of an interesting thing. It's something I'm pretty excited about. It's a pretty good protection in the state of New Mexico. After a lease ends, after there is termination of it and the tenant leaves the home, after that time, there is a clock running. So the landlord will be required to provide the tenant with an invoice, basically, of what they use the security deposit for within 30 days of the tenant leaving the home and the lease ending. What's great about this is that if the landlord fails to do this, the tenant will have the opportunity to file a lawsuit and then get all of their security deposit back. I think a lot of landlords fail to do this. They fail to properly document what they use the security deposit for, and then they're just keeping the security deposit without any legal recourse. So I think tenants should be aware of their rights to details regarding what their security deposit is used for, as well as their entitlement to all of it back if the landlord fails to meet their obligations with regard to its handling.
Right, very interesting. And I wanted to ask you too about that idea of taking pictures or documenting maybe damage or whatever. And again, I think we all understand that maybe not every place you're going to rent is brand new, no scuffs, no scratches, and things like that, and that's understandable. But if you don't document that at the beginning of your lease agreement, you may be held responsible, I suppose, at the end. There's nothing that would keep the landlord from saying, hey, that mark wasn't there when you moved in, even though it maybe was, but you don't have any proof, right? And so those time-stamped photos that you mentioned, maybe even sending those to the landlord with an email that could show that you notified the landlord at the beginning of your lease agreement that these are the conditions of this property as I'm moving in, just so we understand each other.
Yeah, I'd say that's a good idea. Also notifying the landlord that you have this evidence, that you're keeping this in mind, sort of that you're aware of your rights as a tenant. That can be good for basically every party involved. It's good for everybody to be aware of their rights and obligations under these New Mexico state statutes for landlord-tenant law, just so everybody's kind of working in tandem with the law. That being said, a related topic to this is just written communication is usually preferred with your landlord. You want to have written communication, so if you need to reference this, if you have to go to court, it's a lot easier to point to an email rather than for parties to discuss what they talked about, say, 2 weeks ago or even months ago. So written communication is preferred, but if you do have to talk to your landlord in person, only just face-to-face, you do have a right to record that conversation. If you are concerned that your landlord might be violating your rights, or they might just be doing anything else that might be against landlord-tenant law, feel free to record the conversation, because New Mexico is what's called a one-party consent state, and because of that, if you are participating in a conversation, you do have the right to record that conversation, and you are under no obligation to obtain the other party's consent or to even tell them that they're being recorded. This can be good for gathering evidence, particularly when it comes to two specific prohibitions against landlord action, which is against retaliation and illegal eviction. In those situations, it's usually required that there be some sort of intent to illegally evict the tenant or to retaliate against the tenant for them exercising their rights. And in that type of situation, it's really good to have recorded evidence of, say, a conversation. I'm upset with you because of this, so I'm going to evict you.
Very good, thank you. You're watching Solutions from the Street on this Friday morning, everyone. I'm Scott Michlin, along with Megan Cullip. Our guest is Jake Parker. He is a staff attorney with DNA People's Legal Services. We are talking about landlord-tenant issues, and we just have a couple of minutes remaining this morning, everybody. And so I did want to ask about when a lease runs out, because sometimes maybe long-standing tenants, maybe they've been in a place for 5 years and they had a 12-month lease, and now it has run out, and they're still there, and the landlord's still cashing those rent checks every month. What happens when the first part of a lease runs out or passes its expiration date?
So this is an interesting question. It actually isn't addressed in the UORA, but rather common law case law that mostly comes from England. That's where a lot of our American jurisprudence comes from. But basically, there are two types of lease agreements that most renters in San Juan County are going to encounter. And you're going to want to figure out what type of lease agreement you have in order to answer this question of what happens when the lease ends. So the first type is called a periodic lease agreement. This is your typical month-to-month lease agreement, and this type of lease agreement is actually, it renews automatically at the end of every month. There needs to be an actual termination of that lease agreement before it can sort of run out or anything like that. Now, so basically, there is no issue with like worrying about the lease running out.
Sure.
However, with a term lease agreement, this is the other type. This is for a specific set period of time, the lease, and it's usually 6 months to a year. These are less common in San Juan County, but you will still encounter them somewhat. And under term lease agreements, once that term runs out, say the 6 months ends or the year ends, the lease will actually automatically terminate, unless maybe there's a different provision in the lease agreement that changes that. And in that situation, if, say, the year runs out, but the tenant continues to live in the home and continues to pay rent, and most importantly, the landlord accepts rent from the tenant, in that situation, the term lease actually transforms into a periodic month-to-month lease agreement. So if you continue paying rent after the term ends, basically you get a new lease agreement without having to sign anything, and it basically has all the same provisions in your original lease agreement, but it becomes month-to-month.
And all the other provisions, I guess, remain in effect
Certainly. Yeah.
of that lease, right?
Mm-hmm.
And so that's where we are. Very interesting. Very good.
Very good. Well, I don't think I have any more questions. Jake was very, very thorough.
He was very thorough.
Super thorough.
Exactly.
So
The only thing I wanted to add was I think we all realize that not every landlord is out to be hard to deal with their tenants. Not every tenant is out to be hard to deal with their landlord. But if you find yourself in a situation maybe where there's a misunderstanding or maybe there's something just going on that doesn't seem to be getting resolved, there are legal recourses that folks have here in San Juan County, and Jake and I were talking before we came on the air this morning about that DNA People's Legal Services is available for many folks in San Juan County. It's kind of an income-based type of a scale, isn't it, when you talk to folks?
Yeah, let me just talk a bit about our services. So at DNA People's Legal Services, we have multiple offices in the Navajo Nation, and we have 2 state offices. But in terms of eligibility, we are open to all low-income individuals. We have an asset and income limitation, but so long as you are about 200% at or below the federal poverty line in terms of income, you qualify for free legal services at DNA. So if you have any legal issues in terms of landlord-tenant law, consumer rights, family law, government benefits, please contact DNA at 505-325-8886 and press 1 to open up a new case with us, and we'd be happy to assist you.
There you go. Thank you for that, and thank you for coming in.
Yeah.
Now you can wrap up the show. Maybe.
Right.
I know you were ready to go, but that's okay. No,
No,
it's okay.
that was important.
It was.
That
it
was important
And you know what I'm so
information.
glad about, too? Jake's not going to sue us because I didn't have to tell him we were recording this interview.
Oh.
See? It's a one-party consent
That's
state,
right.
so we're good.
We're
Well,
good.
there's
We're good.
microphones everywhere, so maybe I kind of knew.
That's true. Very true. Thank you for coming in.
Happy to do it.
Thank you very much. Jake from DNA People's Legal Services, Jake Parker.
Yes, thanks
So,
for coming on. We hadn't touched this topic yet, so.
We have not, and I think it's an important one. So
For sure.
a lot of important information. And that will wrap up our show, won't
That's
it?
right. That's right. So next week,
Next week,
we have our COVID programming.
we do.
We just keep trucking along.
We just, as long as it's
As-
as COVID trucks along, we'll truck along.
We'll truck
True.
along with it.
Exactly.
So.
But yeah,
Yeah.
there you go.
Same time.
At the same
different topic.
time, different topic, but we want to say if folks have an idea for a topic for this show, Solutions from the Street, we would invite them to send us an email or drop a line or stop Megan in the grocery store.
I heard the go in one, but yes.
Okay, and just say, hey, what about this? So we
Yes.
always appreciate information from listeners and viewers. So KSJE sanjuancollege.edu. And if you have an idea for a topic, we would love to hear from you, or even a comment about the show. Just be nice. Constructive criticism. That's what we're looking for.
Yeah, there's enough bad news in the world.
That's right.
Be nice.
That's true. So,
Yeah.
But anyway, until next time, thanks for joining us, everyone. Stay well and stay safe, and we'll see you back here next Friday here on KSJE. Bye-bye.
COVID-19 cases are high and it's overwhelming our healthcare system. The